All right, Rob, it's your show. Say hit it.
Hit it, Ron.
Welcome to the Q&A show. It's a bonus Q&A for December 2022 on Photofocus. As always, it's Ron, Pepper and Rob Moroto coming at you for another Q&A this week, this month, this time, whatever we're calling it on this bonus show. We have a special guest that's going to give us some legal advice. We're calling this one Happy Holidays. Now let's talk to a lawyer. All right, Rob, how's it going this month?
Hey, it's good. And you know what? I'm really excited about this show today because, as you know, we get a lot of questions and we can typically answer all the photography related ones. Whether we do it well or we do it poorly or we do it completely wrong, we can at least answer them because we are photographers and that is our field of knowledge. But we always get these questions about, hey, what do I do? This client stole my photos, or this company sold my photos to another company. And all these things happen that is more related to legal advice. And we are not lawyers and we are not therapists and we are not, we have to stay within our lane. And today I'm really happy to have David Deal here because he is a lawyer and he is able to talk about this stuff. And so what we have done is we've taken all the questions that we have had up till now, tried to put them into different categories, and then now we get to talk to David about these. So that is why we are calling this Happy Holidays. Now we get to finally answer these questions and talk to a lawyer.
So yeah, thanks, Rob, for sort of distilling down or making like kind of amalgamations, if you will, of all the questions that related to legal things. And we want to welcome in David. David, hello.
How are you guys doing?
Very well. Hey, you know what? Before we talk, let's go ahead and thank our sponsor, and we'll dive in and start getting everything we can out of David's clearly big brain. Our Q&A show is sponsored by Tamron, and they'd like us to mention their 20-40 2.8 lens for the Sony full frame. On the Q&A shows, Rob and I like to go talk back and forth about how to use different kinds of lenses. I wish I had a Sony full frame camera. I'm a Nikon shooter. I'm happy with it, but I don't have a Sony to try this out on. But those 20-40 zooms, I'm thinking very, very good for street photography and exteriors for architectural and real estate photography. And you have that 2.8 throughout. So if you're a Sony full frame shooter, sorry, go ahead, Rob.
Yeah, it seems like a really fun lens to play with. So. Yeah.
If you're a Sony full frame shooter, that's the E mount. Check out the link in the show notes or go to tamron-usa.com.
Yes, and if any of you out there have actually tried it, let us know what you think of it because we'd love to hear about it.
Yeah, agreed. That would be great. We would love all the feedback in the world. And I forgot to mention at the beginning that our questions come from mostly from Photofocus listeners, even though we pull them in from other places sometimes. And you can ask yours at questions@photofocus.com, or you can even do photofocus.com/questions. But all those three things, .com, questions, and Photofocus are in there each time. And send us your audio or email questions. All right. So, Rob, let's jump into topic number one, question number one for David Deal. At daviddeal.com, by the way.
I'm so excited about this. As you can probably tell, I'm cutting you off. I'm sorry about that. But yes, we have been waiting for this for a long time. And I guess we should start with what is intellectual property rights as it stands for photographers? And what's the difference between intellectual property and, say, copyright? Because I think those two words get used interchangeably a lot.
It's a good question, and it's a good place to start. Intellectual property is kind of an umbrella term for anything that is produced by an individual that is covered by the U.S. code that kind of defines what others can and can't do with the intellectual property. So copyright is a large part of the intellectual property world. The other major parts are trademarks and patents, which are, they're not fundamental. They're pretty close to fundamentally different things. Copyright, specifically photography, involves the creation and the protection of original works created by an author or authors. So copyright is only deals with things that happen after the minimum threshold is met for an original work. If something is determined not to be an original work authored by an individual or individuals, it is not protected under the Copyright Act.
Does that mean like derivative works, like taking a photo and making art out of someone else's photo? Is that considered an original work or something else?
That is, you got right to it, because that is the question. It has always been the question concerning derivative works, and I say it is the question because we're in the middle of, literally, like a big picture and small picture, we are in the middle of from an intellectual property attorney's point of view, a very exciting time, because there is what is shaping up to be kind of the seminal case in determination of what makes a derivative work, specifically as it deals with photographs. So for anyone that's not familiar with what is about to be handed down as a ruling from the United States Supreme Court, the case is referred to as the Warhol case. It involves the procedure is a little backwards. The Andy Warhol Foundation is actually the plaintiff in this case, and Lynn Goldsmith, who is the photographer whose work is at issue, is actually technically the defendant. The Warhol Foundation filed for a ruling on whether or not they infringed or not, rather than the other way around. Nevertheless, the Supreme Court is about to hand down a ruling on whether or not Andy Warhol's use of Lynn Goldsmith's image of Prince constitutes fair use or some other kind of, well, the general term is fair use. There are lots of different aspects of what qualifies as fair use. In this case, the issue in the case is whether or not Warhol's use of Miss Goldstein's image went far enough. He changed it enough for it to qualify as an original work itself, or whether or not he didn't go far enough, and it constitutes infringement.
Wow.
So
okay.
Sorry if I stepped in the deep end right away, but from a photographer's point of view, let's just from those of us that would take the photo, and I think you're going to say, or have maybe, that as soon as you click that shutter, you own the copyright. Yeah.
That's correct. That's correct.
And so then we would just be thinking of it, I think, from that perspective. Maybe we'll do another show on the derivative stuff, but as far as we're concerned, we own the copyright, and you're sorry, my head is spinning and we've only been talking a couple minutes, but the copyright is a specific thing. And that's correct compared to some of the other terms that you'll tell us about, but you have the copyright when you take the photo. So I just wanted to
correct. From the terminology in the U.S. Copyright Act is fixed in a tangible medium. So the moment that takes place, and prior to digital, it happened when you click the shutter and the light was recorded on the silver of a negative, even though it wasn't processed and even though it wasn't printed. But yes, as soon as we as photographers capture an image, it is recorded on a tangible medium, we are the copyright holders. The only wrench in that situation is when a photographer is working under a work for hire arrangement. So if you are an employee, if you are a freelancer but otherwise came to an agreement with your client about copyright, absent one of those things, the default position is that the photographer is both the author and the copyright holder at the moment you capture an image.
And I wanted to take the position while we had you here as the photographer. I've been around a while. I have gray hair, but and I've looked into these issues. I've sat in on conferences where we talked about these things, so I am somewhat educated on them. But it's been a while, so I wanted to kind of be in that position and ask a few things just to clarify that maybe people would wonder. And I've been given the advice. Now, Rob and I are not lawyers and all that, but I've been given the advice by lawyers that says, if somebody wants you to sign a work made for hire contract and you're not that familiar with it, the simple answer is no. And the reason is that I have been asked and I said no. And I should give quick advice because we are all photographers. I hope listening are photographers. Somebody wanted me to sign a work made for hire when I was working in my specialty as a 360 guy. And I said, no way. And then the next day they just said, okay, just send us your contract. It's fine. We don't need that. So don't be afraid to say that. And maybe David, you want to tell us more about work made for hire. My understanding is that if someone hires you and tells you what to do and provides the equipment and the schedule and all of everything that has to go, and they just want you to be there to be the cameraman, so to speak, then that's work made for hire. Does that sound like a pretty good layman's definition?
Yeah, and it's so the easy part of work for hire is if you're an employee, the default position is that you are working as a work for hire employee. So absent a written instrument stating otherwise, it is work for hire. But you are absolutely right that even in a situation where a photographer is clearly a freelance photographer and the client is clearly a separate entity and there is no employer-employee relationship, you still can satisfy the standard of work for hire. And you ticked off a bunch of the things that are considered when determining, if push comes to shove, used to determine whether or not something was made under a work for hire. You listed all the major things, which is, who's doing the directing, who's doing paying's not really the issue, but who is supplying the equipment. That is a big one. Yeah. But typically, even if I shot for 20 years, I had lots of different clients. Mostly all the work agreements that I had came close, but not quite satisfied those requirements. I had my own equipment, obviously, but everything else was provided by my clients. Who to shoot, when, they did all the setups, what they wanted, how they wanted the image to look, so forth. The important thing to remember is that absent a written instrument stating otherwise, the default position as a freelancer is that it is not work for hire. So if you take part or you utilize anything that can be construed as the property of your client, equipment being the main one, then you are getting closer, not necessarily over the line, but you are getting closer to the job being considered, legally speaking, as a work for hire.
Maybe you could
the easiest way to solve the problem is to clearly define your working relationship in a written agreement with your client, specifically stating, if not, this is not work for hire, all copyright remains with the photographer. That is the easiest and simplest way to eliminate the potential problem.
Okay. Just tell us, what is the downside of the work made for hire? What is I don't think we said out loud what you're losing out on.
The downside is that copyright is possessed by the person who is the entity that is hiring you. So copyright, even at the moment of capture, when absent a work for hire agreement, the photographer would instantly become the copyright holder. That doesn't take place if you're executing a job under a work for hire agreements. So, I'm old enough to remember when I started shooting and I shot film, and I delivered film to my clients, and there was no real risk of the images that were ultimately used, or even the outtakes, falling into the hands of someone that would copy them and use them. Now it's quite different. It's quite different because there is a huge, and so my point is, copyright was not as important as it is now. Now it's much, much more important because there is potentially an enormous, and by enormous I mean profitable, end that is yet to come after you capture images. Digital images survive online. They can be leveraged. The digital age, which I would consider the last 20, 25 years, there's an exponential increase in the demand for digital images. Yeah. And photographers should be able to take advantage of that when they possess copyright.
No, of course. Like the interesting thing, like you're just saying, that there's this exponential growth in the need and the profitability, but it's also like you were saying, that because we're in this digital age, it's so much easier to copy and to take and to reuse things. And this, you know what, that kind of gets to how we met actually. But before I go into that story, we really just jumped into this because we were so excited about it, but we forgot to ask. David, tell us a little bit about yourself. How did you get here?
I started my professional life as a freelance photographer. I graduated in architecture, but I decided to go right into photography when I graduated from college. I was a freelance photographer for almost exactly 20 years. I worked for primarily as an editorial photographer, but also as a
documentary
photographer that took me around the world. I had a book published about 20 some years ago on minor league baseball, and then a combination of events led me to change careers. I come from a family of attorneys. I'd always considered it, and between the kind of the market crash of 2007, 2008, and the changing landscape in the commercial photography field, I decided to change careers, and now I represent exclusively photographers in matters of infringement.
Wow. So for anybody out there, then if you really want a lawyer who knows photography and is on the photographer side, well, you're the best. You would be the person to call.
It's a perfect time to ask something I was wondering about too. You're in Virginia. Geographically, you're on the east coast of the U.S. And we have an audience that's not just the U.S., but as far as the U.S. law, can you help me I'm in California. Can I hire you if I have this kind of, if I have an infringement issue?
Yeah, it's a very good question. And so the United States we have a uniquely difficult legal system in that we have two parallel court systems. We have the federal court system, which deals only in federal law, which is the U.S. Code. If you see a note kind of with some numbers and a section number that includes USC, that stands for U.S. Code, and that is federal law. U.S. district courts, which are federal courts, deal in federal law almost exclusively. There is a little bit of overlap. And then we have a parallel system of individual, not just state courts, but individual state courts. Some of the older states tend to be in the Northeast, have some common law that deals with copyright, but almost always U.S. district courts are the jurisdiction where copyright cases are litigated. And to your question, because it's the U.S. district court system, I'm admitted in a number of different jurisdictions within the U.S. district court system. Most states have between one and I think California has 4 or 5 separate judicial entities that are distinct. I'm not admitted in all of them, but I'm admitted in a handful of them. Even if I'm not admitted in a jurisdiction, the same law applies, and I can practice with the assistance of local counsel who is admitted in that district. So I litigate and resolve cases and argue cases and negotiate cases throughout the United States.
Oh,
And
and
then so
that's exactly how we met because I had an issue with where one of my images was used improperly, and so I contacted. Well, you know what? I didn't even contact David originally because I didn't know what to do. And like most photographers, when you don't know what to do, what do? You go onto Facebook and you go onto a Facebook group and say, "Help! What am I supposed to do?" And half of the advice that came back was, "Well, you're screwed. They're a big company. You're never going to get anywhere." And then I had one person say, "Talk to David. He will help you out." And so I did. And when we first talked, my major concern was I'm here up in Canada. The company that was infringing was down in the States. And so I thought, well, how am I as a Canadian going to get this done? And I think David, when you and I were talking about it, we brought up the example of, well, if you're on vacation from Canada, going down to Vegas, and you break the law by doing something stupid in Vegas, guess what? You're going to be tried in Vegas. And it's the same kind of thing where it's where the infringement happens instead of where the infringer is from or where the plaintiff is from, right? Did I get that right?
Correct. Yeah, you're. I mean, there's some nuances to jurisdiction, which is kind of the body of law that governs where a case is appropriate to be litigated. But yeah, you're spot on. In general, there's some exceptions, but in general, the proper location and jurisdiction for litigation is based on the defendant. So not always, but almost always. So, for example, I'm in Virginia. There are two U.S. judicial districts in Virginia. One of them includes Northern Virginia, where just outside D.C., if a company is based in Alexandria, Virginia, the Eastern District of Virginia, the U.S. District Court for the Eastern District of Virginia is an appropriate jurisdiction because they are based there, their headquarters are there, they're taking advantage of the laws of the Commonwealth of Virginia and so forth. Now, different states and therefore different U.S. District Court jurisdictions have different rules about jurisdiction. That's what makes our system even more complicated. Federal district court, U.S. district courts follow the long arm statutes, which is kind of the body of law that permits jurisdiction in the states. The U.S. district court jurisdictions follow the long arm statutes of the corresponding state, which is very complicated. But different states, some have very generous long arm statutes, some have very restrictive long arm statutes. But in general, in your case, even though you're not even though you do not reside in the United States, you can still file a case against a U.S. entity that does business in the United States and, at least allegedly infringed in the United States.
Okay. No, and that's great to know because we do have a lot of listeners that are outside of the United States. But let's face it, if you look at the amount of marketing that is happening, there's a lot of it that is U.S. based. So if anywhere that these infringements are going to happen, it is likely going to be in the United States. So it's really good to see that us non-Americans can contact you as well. With that, I do have to ask though. Getting back to the last topic that we were talking about, which was as soon as you take that picture, you are technically the copyright owner. That is assumed. But how can a photographer then protect that? If I came out to you and said, no, this is my photo, and here's the metadata that I have. I've got the raw files still somewhere, but how is there a way to protect those photos in a different way that's more meaningful and less contestable? Because everyone could say, no, that's just a copy. You don't actually have the original, right?
Yeah,
or you didn't actually take it. Like
there are a couple different ways. I mean, there's a huge difference between practically protecting your copyright and legally protecting your copyright. Those two things are very different. So practically, we're in the digital age. Everything happens online. If you are if you want to take steps above the minimum to protect your work, or at least in theory to at least cause some kind of, put up some kind of barrier to people copying and using your work, presumably, you can attach a watermark, you can attach a credit to where you post the image. But I mean, speaking from personal experience, both as a photographer and mostly as an attorney, if an entity or an individual wants to copy your work without contacting you and compensating you for the use, they're going to figure out a way to do it. There's a way to take off watermarks. There's a way to crop images that crop out somebody's credit, so forth. The other thing to do is to include metadata in your original use. So beyond that, there's no real way. I mean, everyone has the opportunity to make screen grabs from a display screen, and it's really, there's not a whole lot you can do to actually preventing somebody from copying your work if it appears online. Legally speaking, is a totally different thing. So to be clear, all the rights under the Copyright Act attach at the moment you become the copyright holder. So when you capture an image, you have all the benefits. You don't have to proactively do anything to avail yourself of the protections under the Copyright Act. But as of almost 3 years ago now, to initiate a claim for copyright infringement in U.S. District Court, you must register your original images with the Copyright Office. That doesn't mean that you are not the copyright holder until you register them. It just means that until you register your work with the Copyright Office, you do not possess the right to file a claim in U.S. District Court for infringement. So on that note, legally speaking, the single most important and valuable thing that photographers can do as copyright holders is to register their image, number one, register their images, but also do it in a timely way. And timely has a legal meaning as well. If images are deemed to be timely registered, which means registered prior to the infringement or within 3 months of original publication, they are deemed to be timely registered. And that matters because timely registered images are eligible for statutory damages as opposed to actual damages. Actual damages just means the value of a lost license. Statutory damages are punitive in nature and based on the actions or lack thereof of the infringer and can go as high as $150,000 plus attorney's fees. So there's a huge difference, legally speaking, between being diligent about registering your images in a timely way and not.
So I want to ask, registering your photos then, that seems like a fairly big process, or could it be a costly process, or is it fairly simple?
It is in all of those respects. It's easy and simple and cheap. It is, especially for photographers.
It'll take a little while. The first time will take a little while, but then it's just a lot of people do it as a matter of what do you call that, routine. So once you get going,
and workflow. I mean, I give my speech to every single client of mine that I can get a couple of minutes in front of. The best from my perspective as someone who negotiates and resolves infringement matters, the single most important thing, and there is a distant second, but it is not even close. The single most important thing you can do as a photographer is get into the habit and build into your workflow registering your images every 3 months in batches. So the U.S. Copyright Office permits batching your images up to 750 images at a time in one registration. It is a group registration. It costs, I believe, $55, maybe a couple dollars more for 750 images. The only restrictions are that all of the images have to be captured in the same calendar year, and all of the images must be either all unpublished or all published. And that's it. And from if you get in the habit of registering your work and they are timely registered, you have a tremendous advantage when it comes to negotiating resolutions to your infringement matters, because most opposing parties do not want to risk litigation when they are staring down the barrel of statutory damages and fees.
Do you have any recommendations for that kind of workflow? Like, are there apps that handle a lot of that for you, like because if I recall, the export of small thumbs and whatever steps. Do you have any recommendations to make that easy?
That's a good question. It's been a while since I have actually myself registered my work and gone through the process.
Mm-hmm.
I know I work with a company called Pixie. There are other companies that effectively do the same thing, which is kind of provide services of, kind of potential identifying potential matches to your work, but they also provide like basic lower level services like registering your work. My clients that I've kind of pushed in the direction of Pixie have all been happy. They have a system where you upload your images in batches and they do the rest, essentially. The only thing the Copyright Office requires is a spreadsheet that has a couple pieces of information on it. Name, don't quote me, but I think, kind of date captured, the title of the image, unpublished or published. And once you get that system down and either develop an automated system yourself or have Pixie do it, that's really all you need, other than the upload of low-res versions of the images themselves.
Interesting. Now, okay, so for example, me, because obviously everything is always about me.
we only know ourselves.
Right, exactly. So, for example, myself, living in Canada, I did have the issue where there was an infringement in the States, or alleged infringement, and the thing that I am starting to wonder is, as a commercial photographer in Canada, should I be registering my work to the Copyright Office in the U.S.?
Ooh, good one.
Absolutely. In jurisdiction in the United States, if jurisdiction is proper in the United States, the only way that you can bring a valid copyright claim is to register your images with the U.S. Copyright Office. Now, there are some exceptions about where original publication took place. Most Western countries, not just Western countries, most countries in the world are signatories to the Berne Convention, which is an agreement among countries to effectively honor the other's laws on intellectual property.
What was the name again?
The Berne Convention, and Berne is spelled Berne.
Okay, thanks.
And it's almost not worth describing because it happens so infrequently, but there is a way that if images were originally published outside the United States, they don't need to be registered in the United States before bringing an action. But rather than worry about those details, the best thing that you can do, even as a non-U.S. citizen, is to register your work in the United States. There's no restriction for doing so. Non-U.S. citizens go through the same process as U.S. citizens for registering their work. And I would argue the United States is such a large space for infringements that it is well worth any photographer's time to do it, because it provides them the opportunity to file suit if required in the United States.
So just to make a fine point on it, thanks for asking that, Rob. I don't know why. This is why we have discussions. I wouldn't have thought about the non-U.S. citizens using that. So that Copyright Office, which I always heard as the Library of Congress, are the same thing, I think. Basically, you can be from Azerbaijan or Peru, and as long as you have $55, they'll take it.
Yep, that's exactly right. Yeah, the Copyright Office is distinct from the Library of Congress. There's a little bit of overlap, but for the purposes of registration and the delivery and the approval of a copyright registration, it is the U.S. Copyright Office.
Okay, probably not worth going into, but I thought those are the same. And real quick, you have to wait for a response as an approval?
You do. So it's another really good question. So the important part of registration is the effective date of registration. There are two different dates. There is the effective date of registration and the decision date. So if you, for instance, Rob, register a batch of images on January 1st, 2023, and the Copyright Office approves that group registration on February 1st, 2023, the effective date of registration is January 1st, 2023. That matters because depending on the timing of the infringement, we want the effective date of registration to be earlier rather than later to eliminate any kind of legal issue about timely registration. And on a side note, as of probably the last year and a half, the U.S. Copyright Office has gotten remarkably better and faster at approving registrations. So 4 or 5 years ago, could be some long lag times. Now I've seen registrations be single image registration applications be approved as early as a week. And probably, again, just anecdotally, the longest it's taken any of my clients in the last year or two has been about 2 months maybe. And relatively speaking, that is considerably faster than where we were a couple of years ago.
It sounds fast for any bureaucracy, but do you know what they actually do? Is a person looking at them, or is there, do you know anything about what the process is for approving?
I don't. I mean, there must be a certain level of trust with the information that is being submitted. For example, if you, Rob, again, just using you as an example, if you submit digital versions of a group of images, whoever is on the other end is trusting that those in fact are your images that you captured. And not only that, but also they're not duplicative of somebody else's work that was submitted, 10 years ago. I don't know whether or not they employ any kind of technology that cross-references those things. My guess would be no. The registration in litigation is subject to, questions about the validity. But I've really never run into that problem. Litigating, I've really never run into a problem where the application and the validity and the truthfulness of the images themselves have ever come into play. That's never been an issue.
Oh, interesting.
And David, I'll let you go. Oh, sorry. I'll give it back to you in a second, Rob. Just one thing. Dave, you're a photographer and a lawyer. Do you use watermarks?
I don't shoot a whole lot these days. I still do shoot, but I've never really been a big digital shooter. I was a dinosaur even when I was in my last couple of years of shooting. I shot with a 4x5 and at smallest type of film I used was 2 1/4. I never attached watermarks to my images because it was difficult. Judging from my clients, there's a trade-off, like there always is, between attaching a watermark and not attaching a watermark.
For sure. It's one of those big debates of just not bothering, like not worrying too much, and you're taking so much away from the photograph with distraction or whatever, versus protecting yourself. So yeah,
absolutely. And the only thing that I would add is I have a client that is remarkably clever about her application of her watermark, and she benefits because she takes a certain kind of image. She takes like highly stylized portraits of models, and she hides her watermark. It's different with every shot, which is amazing, but she hides her watermark in her images, typically the subject's hair, and so it doesn't detract from the image, and I know where it is and she knows where it is. And it's when push comes to shove concerning whether or not an infringer knew or should have known the image was copyrighted and so forth, those are very helpful facts.
So, before we go any further, I just want to say to our listeners, yes, we will be able to put a link into the show notes for how to, or where to upload your photos and register your photos to, I got this Library of Congress thing stuck in my head now, but it's not
Office.
that. The Copyright Office, that's right. Yeah, so we will put a link to that.
For what it's worth, Rob, I steer all my clients in the same direction. The Copyright Office has remarkably good instructional videos for completing applications. They have dedicated videos, instructional videos for every single type of registration, down to unpublished, published, group, individual, so forth. I highly, highly recommend them. They tend to be about 10 minutes long, but well worth it. And they're accessible directly on the Copyright Office website.
Perfect. So we will put that link into the show notes here. And I've got another pressing question that I want to ask. But before we do that, I'm going to hand it off to Ron to talk about another sponsor. Another sponsor.
Yeah, well, actually, let's talk about actually taking photos for a second. As always, another sponsor is Photomatix for high dynamic range photography, and I know for Rob and I, it solves the problem. It's a great little app that sits in my toolbox, and I use it for when the camera can't cover the full dynamic range. So for Rob and I, that's a lot of interior shots where the sun is outside the window and there's dark parts of the room. So you bracket the images and use Photomatix to bring it together. There's a lot of art done with it. A lot of landscapes it's a great tool for that, where you just can't get all of that brightest and darkest areas all in one shot from the camera. Photomatix, it's hdrsoft.com. Try it. You can try for free. Look for version 7 coming soon. If you want to get in on the beta, get a hold of me. There's lots of ways to get a hold of me. Look in the show notes. And let's leave it there, and let's talk more. Let's stop talking photography and start talking law.
Great. So here is my burning question right now. A lot of the people that I know do photography not on the we do more volume than we do price. So instead of taking one photo and selling for a lot of money, we take lots of photos and sell for a very little amount of money. And that is my area of expertise. That is real estate photography. We take hundreds of photos of houses and charge around a couple $100 per shoot. So we get to the point where if we're paying $55 for 750 images, that will cut into our margins quite a bit. And for the most part, when we're shooting a house, it doesn't really matter because, let's face it, it's not like we're going to be taking a picture of somebody's toilet and that's going to become used by somebody else. But that, in fact, is what happened with us. Well, not the toilet part, but essentially we shot a bunch of pictures and they found one that this company used. And so when it gets to that point where there is so much volume of photos and it cuts into our profit, is there another way, or is there something else that we can do just so that it becomes capable, I guess?
Yeah, I mean, the first part of your question is even at $55 for 750 images, you are, as a photographer, you are overwhelmingly making a good financial decision to register your images. Just to give you an example. The statute under which statutory damages is defined and explained, the minimum statutory damages for one incident of infringement is $750. That's the minimum. So depending upon, every case is different, depending upon the actions of the infringer, that's typically, in my experience, very few courts award the minimum statutory damages, and I negotiate and finalize resolutions I can't even remember the last time I negotiated one for the minimum statutory damages. So, for example, so if you took a group of photographs for a real estate shoot and someone copied them outside of proper license, and you had, let's say, conservatively, 10, 20 images that were at issue, regardless of the content of the images. They could be interiors, exteriors, they could be, shots of the driveway, anything. The same minimum standard applies. So if an infringer copied 20 of your images, they're timely registered, they're looking at minimum $750 per infringement. It's
Wow.
just basic, money considerations. It is worth spending the time and effort it takes to batch and register groups of images. The second part of it is there is an enormous difference between registering published images and registering unpublished images. Generally speaking, taking the time and effort to register unpublished images is a waste of time, because unless you have some kind of hard drive or some kind of source where third parties can easily access those images, they're never going to be disseminated, and they're never going to be at issue for copying. The only images that are going to leave your possession, digitally speaking, are the ones that are published. And by published, that is a legal term that does not mean what most people think it means, just colloquially. It does not mean published by an online magazine or any other kind of publisher. It means made available for copying or sale. So if you have a client and you deliver your edits to that client for review, for final selection, that is publication. So once as a photographer, once you have made your rough cut, your initial edit, and you have preserved some images that you don't want your client to see, or you don't want to waste the time sending all of the images from a shoot to the client, you have made a rough cut and sent, let's say, 100 of your favorites on a shoot to your client. Those are the published images, and those are the ones that you should worry about registering. Everything else is unpublished, and really, they're subject to the same copyright protection, but effectively, it's, in my opinion, not worth the time, because the chances of someone getting access to those and copying those is next to nothing.
So essentially, it's like if I was to register all my vacation photos, it's not going to be worthwhile, because nobody's going to see them except for our family. And if they sell my photos, then, well, that's another issue. But getting into that, though, okay, so if I was to be, one of the things that we do is we shoot for a lot of builders as well. And what we do is we send out, say, 30 proofs. And then they'll say, hey, you know what? I want to buy these 5 images. Should I be registering those 5 that they bought, or the 30 that I sent as proofs?
Okay, so this is you've opened kind of a can of worms that is always, and I say always, I don't say that lightly, always an issue in infringement cases, especially concerning real estate photography work or architectural work, construction work. There are always multiple parties involved in the transaction. So you described shooting for builders. In my experience, I represent a lot of real estate photographers, a lot of architectural photographers. There are always all of these third parties that have had some part in the process. There's like a window company, there's a floor company, there's an architect, there's an interior designer, there's a lighting company. And what tends to happen is that those third parties gain access to the images that you have sent to your original client, whether or not surreptitiously or your client outside the terms of the agreement you've made with it, disseminates those images improperly to those third parties, with or without kind of implicit permission to use them. That is the story of 99% of the cases that come my way. And so your question is a really good one. It depends, obviously. It depends if your client made all of the images that you sent to it available to third parties, or either sent them to or created some kind of source where the third parties could gain access to them. If you, in my opinion, if you make an edit and you, legally speaking, publish the images to your original client, all of those should be on your list to register, because you have dramatically increased the chance that those images are going to be disseminated and copied.
No, that is a very, very good thing to know, because yes, we do run into that all the time where we have you're right, like I'll shoot for a place and I'm like, oh, can we share this with our interior designer? And they always use that term, share, and right. It seems very kindergarten polite, but it's really not. Right. And because of all of that, you brought up another thing where you said contracts. And I want to touch on this as well, because with us as real estate photographers, we don't ask all of our clients to sign a contract before we go out and shoot, because it's real estate. What we have is a little checkbox on our online booking thing that says, here are the terms and conditions. Bang, click it and book. But there are times when people call us and they book a shoot and we don't get them to sign anything. Now, the question that I have is, if you are registering all your images to the Copyright Office, do you need a contract?
Yeah, it's a really good question, and again, it is at the root. This issue is at the root of almost all my cases, which is when a matter of infringement comes up, how invested or not invested are my clients with their original clients, where they can afford to kind of go after third parties, and where does the legal liability kind of end? So every situation is different, because there's some clients that you can, as a photographer, you can burn. There are others that you can't. And my clients that do the best job with this issue are the ones that get out in front of it, just with everyone. And by get out in front of it, I mean either insist on a written contract that clearly states that the license to which the parties are agreeing is limited to the client and nobody else, and that any use of any kind by third parties needs to be negotiated and so forth. Those are great example. That's a great example of a contract that photographers, in my opinion, should insist on before they go any further. Now, you mentioned kind of a click-through online. That is equally as good as what I've just described, to make it, to put the burden on your client to read and agree to your terms before they get anything. Before they get a download, before they're able to pay for an upcoming shoot, have them click through terms that, again, clearly state that by far the most important thing is photographer retains copyright, period. Anything else is second. But if you want to get more into it, you make it clear in writing that any dissemination of any kind of these images to third parties is subject to an additional license that needs to be negotiated with the photographer.
I was going to ask about that.
I shot for a long time, and this I say I give instructions like this is an easy thing to do. It's not an easy thing to do. Photographers are almost always in the weakest position of all the parties that are involved, right? We have benefactors that send us work, and if we offend our benefactors, we're going to lose our job. But there, in addition to any kind of written agreement, there's a skill to educating your client, before you enter into any kind of written agreement, which is, look, I've had an issue with this before, or I anticipate there might be an issue. There are a lot of people involved. There's a nuanced way to do it where you are absolutely clear with your client what you expect You take intellectual property very, very, very seriously. You would like to avoid any kind of problems before they happen. And this is the easiest way to do it, to clear any kind of use, any kind of dissemination with me before you do it.
That's great. Like I do that with our clients, where I will just say, but I don't say like, hey, you can't do this. I pose it the other way around. It's like, oh, you're a builder? You got to show home that you're shooting? You want me to shoot? Great. That's fantastic. By the way, after I shoot it, just tell all your trades that they can buy a secondary license as well. And I'll give them 50% off that license cost right off the bat. And so in the beginning, they know.
It puts us in the position as the professionals to kind of be the educator in that area. Because I wanted to mention that, like Rob, I know you told me what happened with your photo. And by the way, I want to say that real estate photography usually isn't something that gets printed on a magazine or used for advertising, but Rob's is so good that it got taken away and used this way. So I don't want to get myself in trouble, but they should have known better. That company should have known better. But I think we're usually talking about, I want to bring this around, we're usually talking about someone who doesn't know, they don't mean anything by it. So they might just be saying, oh yeah, like the real estate agent, oh, I have these great photos. And the new owner of the house says, can I get a copy of those photos? Oh, here you go. And then they don't really know. And they're happy to have them. And then they go and use them to, sell the condominium as a rental. And use them on and on.
I'm nodding along with you because that is the fact pattern of a countless number of cases that I've handled. Oh,
good. Yeah, that's something. Yeah, I have experienced there too. But more often than not, it just is. A very common one would be, can my stager use the photos too? Mm-hmm. And then you get into that situation where I think you're just bringing up that. Do you want to burn a bridge or do you want to build a bridge? Do you want to be the agreeable one? And where are you selling yourself short? Where are you missing out on if you get between a couple hundred and several hundred for a real estate shoot that is used for that house? And I know in my area, the house is sold by the time the photos get up typically. So that's the use of them. But that stager, the rental, the anyone else that uses the photos to do an ongoing business, now the value of those photos are different. And there are tools, it's been a while, but there are tools for how much should I license an image for? And it all depends on the use and the time and the what do you call it? The geographical area. All those things come into it. So you might have delivered 35 images for a house for please, real estate people, don't deliver that for $99. Let's say you've done 35 for $400. And I am in the Bay Area, so that's one thing. But now that's done. But if someone is using just one of those images or say 3 of those images to ongoing sell over time, that's a whole different licensing situation. So don't sell yourself short. And I bet David will agree with me.
I agree.
Okay.
Again, you guys are like spot on with every single primary issue of this subject matter. This is, I've lost track of how many times that exact scenario, I've been presented with that exact scenario by the time a client comes to me and says, well, I noticed the infringement. I reached out. I said that they could have it for $50 because so-and-so. There is, we all know as photographers, I did not shoot real estate, but I shot portraits, I shot images, documentary work that had a value post-shoot. And so there's a tremendous reuse value to all of the images that we take. And just because you completed a job for, in the end, 30 or 40 images for a real estate listing does not mean that anything that comes after that, any kind of entity gets the benefit of your original job. For one, market rates for, like you said, Ron, a single image for use on a commercial website is fundamentally different than the price that the original client paid for the shoot for the purposes of listing the home. And so I'm often, if not, weekly in the position where I have to kind of clean up a little bit when I go to the opposing party and say, hey, look, these are not, it's not apples to apples. You took it and used it for something else. The bigger picture, though, Ron, is exactly right. You were exactly right. Those photographers should not be willing to sell themselves short because the infringement may at least appear at first to be kind of a bonus source of income. Photographers should not treat the unauthorized use of their work in that way.
Yeah, good. Huh. In fact, that would be one of the main messages from me. I'm Ron Pepper. I'm on the show. My main message to photographers is don't sell yourself short, and don't just say yes to keep necessarily. I mean, definitely say yes. Believe me, I'm more Canadian than Rob in the goofy, friendly areas, but I also know when to put my foot down and say that's just not okay. When a client, we're doing a huge job for hotels years ago, and they say, yeah, we're going to need the original RAWs as well. I'm like, no. Someone I was working with, I got to look like immediately. And I go, that's just not appropriate. That's not what we're doing here. Those RAW images are nothing. I put them into an elaborate HDR 360. There's a lot of steps there. So anyway,
no, exactly.
And if you have any questions, ask around. I don't know. You guys are recommending Facebook. I don't know, but with
it works.
Putting aside jokes of Facebook. Yeah, but I was going to say, putting away aside the jokes about Facebook, the thing I use it for personally is photography groups. Okay, and there's one Seahawks group, but it's photography groups, and I go there to ask questions and when appropriate to answer them. So like it's that great teacher and learner situation where you answer what you know and you ask what you don't, and so photography groups on there can be really helpful. But again, if you're just wondering if it doesn't feel right, it might not be. And
all right, I've got one last question, and this is very selfish of me because this is a situation that may only actually apply to real estate photographers up in Canada. Okay, so our MLS system has a requirement on there that the realtors that are uploading photos are giving the MLS system ownership of the photos that they're putting on there. Now, of course, if I'm the license holder and I send my photos to my client and provide them a license and then they upload it, they are giving ownership of something that they don't actually own onto MLS. Now, to get around that, one of the things that we have done is we have created a specific size that meets the exact size that they need and not bigger. And we want to say that we are giving full ownership of that size, that resolution of that image, of that print of that image, I guess, the digital print of that, to the realtor so that they can pass on that ownership on to MLS. Is that actually the right legal way of doing it? Because I still want to maintain the ownership of the original image, but I don't want my clients to get in trouble by giving ownership of something that they don't actually own. So can you have two the same image, just duplicated in some way and provide different ownership for that size?
No. so the MLS, I mean, the same image in different sizes and different resolutions. It's the same copyrighted work. MLS, the MLS systems are all different. There are tons of them. Generally speaking, when a entity that uploads images to the MLS, let's say an agent for whom you've shot, they upload an image to MLS. The terms typically they're all slightly different, but typically the MLS has kind of not force, but in MLS terms include the uploading party bestowing some kind of rights, maybe not ownership. And ownership is a really funny word in copyright because it doesn't really mean anything. It's either you're the author or the copyright holder. Those are the two distinctions. Most MLS systems that I've read the terms don't purport to be taking copyright. What they insist on is the uploading party granting a license to MLS to use the images as they see fit online, or some other connection to the MLS system or the listing. What copiers of images that have been displayed to MLS sites often get wrong is that because the original uploader granted these limited rights to MLS, those rights extend to anybody that is on subscribes to MLS and wants to copy those images. That is not correct. You are an agent or a photographer, if they're doing it directly, by uploading images to an MLS system, is not granting the MLS and anybody that is subscribed to the MLS system to copy those images. So you just need to be really careful with the terms of your specific MLS. Typically, your license is a limited license, no exchange of copyright, no transfer of copyright. You are granting the MLS system a license to display those images on their platform. That's it.
One Rob's solution of the size could be a bit of a practical solution, couldn't it? Where if I share, let's say they require 1600 pixel long side, and I deliver that, well, that's not big enough for some uses. So it would practically, in a practical way, exclude them from some uses, right?
Absolutely, yeah. And it's a good,
they can't just come back. They can't just come back and say, well, I can use it, so you have to send me the bigger one, of course, right?
Absolutely. Like, legally speaking, there's no distinction between a version of the same image. But Rob, the practice of effectively limiting the use of the MLS system of a, not necessarily a low res, but a lower res version is very, very smart, because any entity that is going to copy that from the MLS is going to be from that point on, they're going to be limited to the best, the absolute best version of that image that you uploaded, which is going to be considerably lower than the full one. So from that point on, it is a disincentive for people to keep on copying it, because it's going to degrade even smaller, even a little bit. It's going to continue to degrade the more people copy it, and less likely to actually use it based on that alone. Yeah. So it's a smart decision to make. What you just described is kind of limiting the MLS versions to ones that meet the minimum threshold and therefore can't be used in print per se, or can't be expanded into some kind of digital use.
Yeah, I can hear listeners yelling at their device, asking about sharing apps, and what are we giving up when we share on Instagram and the apps. And it sounds like when you mentioned that you upload to MLS and there are terms, and they try to assume some. I know. I'm glad to hear that ownership's not a legal term. But anyway, what about? Do you have anything? I know we can't go too long, so maybe do you have any advice about sharing apps and what we're giving up, and just to set the expectation?
They're all slightly different, but I'll just use Facebook and Instagram as an example. They tend to be similar to what we just described at MLS. If you read the terms, they're along the lines of, you are, by uploading, the act of uploading an image to their platform, you are giving the platform in some cases, an indefinite license worldwide to do with your images as they see fit. So if they wanted to, they could use it in an ad. They could, whatever they want. They could use it on some kind of internal document or email or something like that. The same dynamic takes place with infringers that access images on Instagram and Facebook. I mean, it happens. It's 50% of my cases, if not more. That's where they source them. And often, not always, but often, the reasoning is, well, I got it from Instagram. That's what we do. That's the whole purpose. We share images, we credit people, and that is false. By uploading an image to one of those platforms, you are not extending a license to anybody that happens to use that platform. I tend to think it's bad enough that you're extending a license to Facebook or Instagram because they can do what they want, but that's kind of the price we pay. You are absolutely not extending a license to anyone who uses it. I will add that there is an outlying case, and it's a single outlying case in the Southern District of New York that says that holds that you are indeed extending a license to all users. But that case is effectively on an island, somewhere in legal, kind of legal obscurity.
So if just for our listeners, if I was to provide an example of that, so it would be like if my client, the home builder, was to post an image up onto Instagram, and then the cabinet maker shares that and says, "Hey, look, this is the project that we did," onto their Instagram. They didn't get the photo from us; they just shared it through Instagram. Is that the kind of scenario that we're looking at?
Yep, that is infringement. And unless you have negotiated, unless that third party has negotiated a license with the copyright holder, not your client, they have infringed. Now, that's where we start. Now we all know that things get much more complicated than that, and you have to, as a photographer, you have to negotiate these relationships between your clients and their clients and their the third parties. But yes, legally speaking, unauthorized use is infringement, and the only ways that use can be authorized is by the copyright holder.
I have one more. This is completely off the rails. One more thing that I like to bring up sometimes is buildings. I understand that in other countries, you're not allowed to. Like, for instance, some rule against taking pictures of the Eiffel Tower, for instance, and we've had wonderful conversations on the street here in the U.S. a couple of times when people have said, we don't allow photos of our building. And it wasn't even me, believe it or not. Someone that I was on a photo walk with, Dave Wilson, he's been on the show, goes up to the guy and educates the heck out of that guy. Says, you cannot tell us. We can't be anything on the street. And then he tries to say, well, you can't take a picture of the address. We're like, dude. And we took a few minutes, but I understand that in other countries there is some rule, and I know this is off the cuff here, but do you have any do you know about that? Because I find that fascinating that could be true.
I can't speak to it because I don't really know. I would find it remarkably difficult to believe that is the case. I mean, just the idea that an otherwise copyrighted piece, whether or not is a painting or another original work or a building in this case, because just for the sole reason that it is included in a photograph, that makes no legal or logical sense to me at all. I mean, that would eliminate copyrightability of nearly all images that people ever take. I mean, there's a limit. Obviously, there's a difference between taking a picture of, let's say, the Eiffel Tower that is limited to the Eiffel Tower in the sky, and an image that has the Eiffel Tower in the background of a cityscape. There are practical differences between them, but yes, I think the limits on photographers capturing otherwise copyrightable designs is very, very loose.
Well, for instance, if the Hulk falls to Earth in the movie, and it goes past some famous New York buildings, does Marvel have to do any licensing for that compared to, from my understanding, and this is my understanding, that if Black Widow is climbing up the Eiffel Tower, that's a whole different story. Now they have to actually do some negotiating there, and that's kind of where it all came from. And I also find it okay for a big movie or something, the city could do something, but for photographers just going around shooting and they can be told by some, I don't know, security that they can't be taking photos, I also find that completely.
Yeah, the only real codified restriction to what you're describing is the statute escapes me at this point, but it's part of the U.S. code. There's a limitation on the copyrightability of images that are taken on private property. So if someone can demonstrate, it has nothing to do with the copyrightability of the subject matter. It just means there's a limit to copyrightability if you are on private property capturing the image, or in this case, capturing the image. So that I've reviewed the statute a couple times when the facts have been appropriate in cases, but for the most part, it never comes up.
Yeah, and the other thing that I've got to say, Ron, on that part is the one time that I did get asked not to take photos of something, the security guard that said it brought up a very good point. He said, "You cannot take photos here," and I said, "Well, why not? It's an outdoor space." And he said, "No, you cannot take photos here," and he pointed to the ground and said, "You are on our private property. Mm-hmm. You cannot do that on our private property. Please leave." And that was a very good point, right? It wasn't about photography. It wasn't about the building. It was about me physically being trespassing because I was doing something that they didn't want us to do. Mm-hmm. And then, you know what? We've been on here for just over an hour, and I think that we could keep talking with you, David, forever. There's so many things that we can talk about, and but you know what? There is a soccer game going on that we have all got to go start drinking and watching and enjoying. So with that, I'm going to just say, David, where can people find you? Thank you again for all this, but where can people find you so that they can get more information from you and have you help them?
My website is my name, which is daviddeal.com. And Deal is spelled D-E-A-L.
Wonderful.
David, let's
and then
make
Ron.
a deal.com. Do you have any just parting kind of, I like to call Rob, he comes up with some of these greatest bits of advice. I like to call them Rob's gems. Do you have any just kind of your favorite piece of advice that you'd like to give as a parting gift on this holiday season?
Legally speaking or otherwise?
Oh, anything. The floor is yours.
My 10-second, 15-second speech to all my clients is it is beyond worth your time to register your images and do it in a timely manner, by far.
Good. And if once you do it once, it's easy and might be very well worth it. Thank you very much. He's daviddeal.com. He's robmoroto.com. I'm ronpepper.com. We've been here over an hour already, so let's just say get out there shooting. Don't worry about all the legalese until someone throws it at you, and then ask questions. Call David Deal or your local person. All right. Thanks for listening, everybody. Have a great holiday, and adios.